A baker's artistic ambition nearly lead to his execution for treason. These are not merely interesting historical footnotes. They are windows to a world where logic has slept for a long time, superstition is supreme, and the boundary between the sacred and the secular is drawn in the most unexpected places. So, sit still and be comfortable. Let me tell you the extraordinary story of how medieval Europe created legal systems one after another. This is a journey into a world where even pigs need lawyers and geese can become knights. In this world, the simple act of baking bread might be regarded as a betrayal of God. Imagine such a picture. In 1396, the French town of Paris. The early morning mist enveloped the cobblestone streets. The church bells resounded through the red minus-tiled roof. In this picturesque medieval setting, a pig is about to make legal history. This pig is ordinary in all aspects. It is unremarkable and belongs to a local peasant family. Every day she rummaged through the garbage rolled in the mud, and did all the things that pigs have done since ancient times. She never expected that on the special morning, she would become a defendant in one of the most famous trials in medieval history. What happened was both tragic and simple. A child playing in the street caught the pig's attention. Perhaps the child is holding food in his hand. His pig is just hungry. In the moment of an animal instinct, the pig launched an attack and seriously hurt the child. The child later died of his injuries. In our world, this would be a terrifying accident. Such matters have led to regulations on livestock control, which may offer some compensation to families, of course, by slaughtering pigs. But that was in the Middle Ages, when the boundaries between humans and animals, reason and faith, accident and sin were completely different from those of today. Look, people in the Middle Ages lived in what we call a moral world. Everything, every living being, every movement, and every event exists within God's great design. Nothing is accidental. If a pig kills a child, it is not merely an animal instinct. This is a choice made by a moral actor, and a moral actor can be responsible for their own actions. So the people in the town did what they thought was logical. For murder. The trial was carried out just like a human murder case. That pig has been officially arrested. Yes, it has been arrested and is being put in the town prison. A policeman was assigned to guard her. The court date has been set. An official document was drafted, accusing an unknown pig of deliberately murdering a young child. But this is where the real fun lies. According to the law of the Middle Ages, even pigs had rights. The court appointed a defense lawyer, a genuine lawyer trained in can unlearn civil law, who now finds himself in a rather unique position to defend the life of a pig before a peer jury. Well, not her peers. The jury was composed of 12 respected people in the town. But fortunately, history has forgotten the name of this defense lawyer, who meticulously planned a legal debate that was actually quite complex. He pointed out that animals lacking rational souls could not develop the intentions necessary for murder. He believes that the behavior of pigs is based on natural instinct rather than malice. He even suggested that it might have been the child's careless behavior that triggered the attack. The prosecutor countered that the pig's behavior demonstrated deliberate and far-sighted malice. Continuous and vicious, transcending mere defensive behavior. The most detestable thing is that this pig showed no remorse after the act, which is a clear sign of a stubborn criminal mentality. The trial lasted for several days. Witnesses were summoned, evidence was presented, and legal precedents were cited. Finally, the jury withdrew and began to deliberate on what might be the most unusual case in the history of jurisprudence. Their verdict was first-degree murder. His sentence was hanging, the same method used to execute human murderers, because consistency was of great importance in the judicial system of the Middle Ages. But the story did not end there. Oh, no. It has become even stranger. The execution ceremony of this pig was very grand. She was dressed in human clothes, shirts, trousers and jackets, because a criminal sentenced to death should face death with dignity. She was taken to the gallows on the street, where hundreds of people gathered to witness this unprecedented scene. The executioner fulfilled his duty with professional competence. The pig died and might be very confused about the whole thing. According to the logic of the Middle Ages, justice was served, but the commotion caused by this case far exceeded the scope of the case file. The news spread throughout France and then throughout Europe. Some people praise God for carefully exercising justice over all creations. Others are worried that the entire incident has come close to the danger of blasphemy. Bishoply Al is of particular concern. If every parish starts to execute animals on its own, who knows what the outcome will be? What if they began to judge cats for witchcraft and dogs for theft? Where will it end? Therefore, within a few months of the pig trial, the church issued a new decree. Without the explicit authorization of the church, no animal can be tried for committing a crime. In other words, even pigs now need the permission of God's middle-level managers to face justice. This may seem like an excessive expansion of bureaucracy, but it has actually created something extraordinary. This is the world's first systematic legal framework for dealing with animal crimes. Over the following centuries, hundreds of animals were tried in European courts. Roosters were accused of witchcraft for crowing at unusual times. I got accused of immoral behavior. Little was fined for illegal intrusion. Even insects are sometimes put on trial, although it is quite challenging to have them appear in court. Each case must be approved by the church authorities, who have established detailed procedures for these trials. Animals must be formally served with legal documents, although it has never been entirely clear how to serve a summons to grasshoppers. They have the right to legal representation. They could even appeal to a higher court. The most famous of these cases is the mouse in autumn. In 1522, rats in this French city were accused of destroying grain crops and leaving them to fend for themselves. They were formally summoned to court, but failed to appear for trial. Their court-appointed lawyer argued that his client was too afraid of the local cats to reach the court safely. The judge found the argument very convincing and thus dismissed the case. To modern people, these trials may seem like elaborately designed jokes, but people in the Middle Ages took them very seriously. In fact, they reflect a worldview in which every living being has its own place in God's hierarchy, and every action, whether human or animal, has moral significance. This is not the original idea. This is complex theology. Medieval scholars spent centuries studying the relationship between the will of the gods, the laws of nature, and human justice. They believe that God's justice is perfect and universal, extending to every corner of creation. If God can judge sparrows, of course human courts can also judge pigs. Animal experiments also have practical uses. They offer the community a way to deal with traumatic events, shirk responsibility, and reach reconciliation. They strengthen the social hierarchy and religious beliefs. Yes, they eliminated dangerous animals, although the way they did so maintained the moral order of the community. But perhaps most importantly, these trials established that justice is a universal principle. No matter how humble a person is, they are not subject to the attention of the law. This is a radical idea because in this world, justice is often arbitrary and capricious. Those in power can evade the consequences, while those without power suffer. The pig experiments on pig slices not only created a new animal legal system, it helped establish the notion that the law itself should be systematic, predictable, and fair. Perhaps this is just a small step, but it is a step towards the world we live in today, in which even the most humble citizens can look forward to having their day in court. If you think the trial of a pig for murder was the strangest legal case in the Middle Ages, let me introduce you to Sir Hiss of the Pond, a knight whose brief military career will reshape the Valric law throughout Central Europe. This is somewhere in Bohemia in the 14th century. The exact location has passed with time, but the story has been passed down in the chronicles and deeds like a feverish dream. Imagine a typical medieval championship. Colorful pavilions dot the green fields. Knights in shining armor are testing their skills. Crowds are cheering for their favorite ones. Merchants are selling everything from sacred relics to suspicious meat pies. The championship was a sports event of their time, but their significance goes far beyond this. They were displays of power, opportunities for young knights to build their reputation, and carefully planned dramas aimed at reinforcing the values of medieval society. Honor, courage, weaponry and skills, loyalty to God and the monarch. These are all the ideals that the championship promotes. But by the 14th century, the competition had become a routine matter. The same knight riding the same horse, following the same elaborately designed rules, staged the same elaborately designed marshal's heroic performance. Everything has become foreseeable. This unknown Bohemian nobleman made his appearance. History only remembers his sense of humor and his complete lack of common sense. Tired of the predictability of the competition culture, he decided to liven up the atmosphere with a prank that he might have thought harmless. He commissioned a complete set of miniature plate armor to be made for his pet goose. Let this image be deeply rooted in people's hearts. This goose is the most aggressive and elusive bird in the band, dressed in custom minus-made medieval armor and wearing a small helmet. This nobleman's armor was crafted by artisans who made equipment for human knights. And they also paid close attention to details and the quantity of materials. He named the goose Mr. Hissing of the Pond, registered it as his official attendant, and announced that the goose would participate in the opening ceremony of the competition. Other knights thought this was very funny. This is a person who is so confident in his chivalric abilities that he can mock the entire chivalric system. This is equivalent to driving a beautifully decorated shopping cart to watch a Formula One race in the Middle Ages. The audience also likes it very much. In the Middle Ages, people had a highly developed sense of absurdity. The sight of a noble goose wading back and forth in tiny armor attracted their appreciation of wonders and satire. However, anyone who has ever been around geese knows that they are not particularly concerned about human entertainment. They are proud, territorial birds with their own ideas and have no sense of humor at all when dressed up as medieval knights. At the opening ceremony of the competition, Sir Heath clearly felt that he had had enough of all this nonsense. According to the chronicles, he somehow escaped from his high position and then began a violent act that could only be described as running amok. Imagine the scene. A fully armed goose flapped its wings angrily, hissing and charging through a group of frightened spectators. The tiny armor did not slow him down. If there is any difference, it is that this seems to have given him confidence. It will attack anyone who gets in its way. There is a miniature metal beak guard on its beak, which can turn every peck into a real weapon. The squire tried to catch him but ended up biting one of his hands. The goose cast its gaze toward a larger prey. The Destray warhorse, a large warhorse that knights ride on the battlefield. These animals were raised for courage and trained to face the chaos of medieval wars. But clearly no one was ready to face the attack of the armored foals. The horse, in a panic, stood up straight and threw its rider down. The rider landed heavily on the ground in front of hundreds of witnesses. This triggered a chain reaction. The other horses were frightened and their riders tried hard to control them. Within minutes, the carefully planned race fell into chaos. The dust settled. 3 knights were injured, 2 horses were seriously wounded, and Sir Heath by the pond died a tragic death. Ironically, it was precisely that horse that frightened him to death. The injured knights were not happy. The match officials were also unaware that they had spent several months organizing a match that was ruined by a goose. Church representatives were shocked by this, believing it to be a mockery of the sacred bond between knights and gentry. But what really worries the authorities is the legal impact. The laws of the Middle Ages had very clear regulations on what constitutes legal knight-time activities. The privileges and responsibilities of the knights have been carefully defined through centuries of legal precedents. If anyone could simply declare farm animals as gentry, what impact would that have on the entire field of duty system? Less than a week later, an emergency meeting was held. Legal scholars, church officials and representatives of the Knight Order met to determine which laws, if any, had been violated and what measures should be taken to prevent similar incidents from happening in the future. The result was a remarkable piece of legislation, which modern historians call the Goose Act. Its official title is much longer, but its essence is very simple. No one, regardless of their status, can confer noble titles upon animals, nor can they dress them in the crowns of human warriors, nor can they allow animals to participate in rituals reserved for humans. This decree was written in the rigorous and comprehensive language favored by legal scholars. It clearly stipulates that this ban applies to domestic animals, all kinds of poultry, field and forest animals, as well as any other animals, whether domesticated or wild. It encompasses a variety of penalties ranging from fines to the loss of ownership for violations. It even mentioned the specific issue of animal armor, pointing out that such equipment can only be used for legitimate military purposes. Although what legitimate military purposes geese might be used for has not yet been explored. This law was adopted throughout the Holy Roman Empire and spread to other parts of Europe. Decades later, legal scholars would invoke the Goose Act when dealing with cases involving improper treatment of animals or abuse of noble titles. That this law brought about consequences that no one had anticipated. By clearly stipulating that animals cannot have titles or participate in human ceremonies, it actually clarified and strengthened the legal status of the legitimate nobility. It reinforces the notion that chivalry is a sacred trust that cannot be ridiculed or belittled. More importantly, it established the principle that legal privileges are accompanied by legal responsibilities. Knights enjoy special rights because they play a special role in society. They cannot grant these rights to their pets merely for entertainment purposes. The Goose Decree might have initially been a response to a man's special sense of humor, but it became an important step in the evolution of political thought in the Middle Ages. It helped establish the notion that social systems were too important to be treated as a joke, and even the most powerful nobles were bound by laws and customs. Sir Heath of the Pond became a folk hero in Central Europe. The storyteller polished the story again and again until the goose became a symbol of innocent creatures falling into human folly. Some versions claim that his soul haunts the tournament, invisibly slapping against the tilted court, reminding people that pride precedes fall. This story spread throughout Europe and became the favorite of the noble courts. Its purpose is to warn people not to take sacred institutions as a source of entertainment. And at the same time, it is a tribute to the unpredictable power of nature, which can weaken human pretensions. Medieval artists incorporated the image of a goose and armor into everything from painted manuscripts to church carvings. This theme becomes a symbol of human pride and folly, as well as the wisdom of accepting one's rightful place in the sacred order. But perhaps Sir Heath's most enduring legacy is the legal principle he established during his brief career. Even when dealing with absurd matters, one must take the law seriously. The Goose Decree indicates that the legal system of the Middle Ages was mature enough to distinguish between legitimate customs and pure entertainment, as well as between sacred traditions and blasphemous mockery. In a world where the line between seriousness and stupidity is often blurred, the law provides a clear message, and sometimes it is obvious that a goose is needed to teach this lesson. If Sir Heath made medieval Europeans aware of the limitations of humor, then Count Henrik von Schwarzburg is about to make them aware of the limitations of liquid courage. The year was 1364, in the German states of the Holy Roman Empire. The exact location is passed over time, but its consequences will spread throughout European law in the coming centuries. This is a typical autumn championships season. It was the golden period of harvest, with the weather still pleasant. Knights from all over Europe gathered together, showcasing their skills and resolving their disputes in what was called civilized battles. Heinrich von Schwarzburg was a typical figure of his class, a minor nobleman, a big ego, a decent warrior, with an undignified desire for honor and no idea at all when to stop drinking. Knights in the Middle Ages should have drunk alcohol. This is part of their social identity. In the competition, wine and malt liquor flow freely, partly because water in the Middle Ages was often unsafe, but mainly because alcohol was regarded as a social lubricant that could promote the kind of noisy calm radity were valued in the night culture. But Henrik went further than most people. He loudly told all those who were willing to listen to him that when his spirit was strengthened, he would play better. He claimed that alcohol could enhance his reaction ability, stabilize his hands, and open his heart to accept God's guidance. This is not entirely without reason. Medieval medicine tells us that wine and malt liquor have medicinal value. Many knights did find that having a glass or two of wine could calm their nerves before battle. The problem is that Heinrich never stopped at one or two. On this special day, Heinrich started drinking at dawn, which is not uncommon for a match day, as the cavaliers usually begin to prepare several hours before the actual game. But at the start of the first competition, witnesses reported that he was wobbling on the saddle. When attempting to mount, his spear dropped to the ground 3 times, and he loudly declared that the glory of Saint Michael was guiding my goal. If Heinrich were to compete with other knights, it might just be embarrassing. Medieval championships had strict safety regulations, and officials would usually expel obviously injured participants before they could harm themselves or others. But Heinrich did not attack his fellow knights that day. He was participating in a shooting practice performance at that time. It was a rotating wooden target used to test accuracy and time. This should be a safe and controlled exhibition, allowing the audience to warm up before the main event start. On the contrary, it became a masterpiece where alcohol and medieval weapons could not be confused. Heinrich charged into Quinta N with all the passion of a knight facing a life minus and minus death struggle. He didn't hit the target at all. Even for a conscious knight, this was quite normal. Quinton's job requires precise timing and coordination, but Heinrich didn't stop after his failed pass instead. He continued to charge directly into the crowd of spectators. Specifically, he directly rode into a group of monks who were invited to bless the entire process and pray for the safety of all the participants. The next scene was like a black comedy. Heinrich's long spear was still getting ready for battle when it hit his brother Welsbird's Marcus in the chest. The monk flew backward towards his brothers, causing a domino effect. Heinrich's horse was trained in combat, but was confused by the enemy's lack of response and continued to charge through the casualties of the clergy, while the rider shouted blessings in Latin. By the time Heinrich finally took control at his mount, he had wounded 3 monks, scattered communion tablets all over the arena, and completely destroyed a portable altar set up for the cream Ines match mass. The direct consequence is chaos. The injured monks were carried away on stretchers with blood and protest trailing behind them. Competition officials held an emergency meeting. The crowd was initially silent in shock, but later began to murmur about God's judgment and God's wrath. But the most unforgettable sentence of the day was said by the Marcus brothers. When he was carried away, he raised his head and declared, "I'm here to pray for peace tonight. I should have prayed for myself. I'm very glad to tell you all that Brother Marcus has fully recovered and lived to be 73 years old. However, for the rest of his life, he has been very careful to avoid participating in outdoor activities." The shockwaves this event brought to medieval society far exceeded the playing field. The church was terrified, but only because of the harm to the saint, but also because of the obvious mockery represented by Heinrich's actions. Secular authorities are worried that this will set a precedent. What impact would it have on the carefully balanced relationship between church and state if knights could attack clergy without punishment while claiming to be guided by God? The competition was held on the territory of Duke Frederick of Suabia. A few days after the incident, he convened an emergency meeting. Among those attending the gathering were legal scholars, church officials, representatives of knight orders, and even some ordinary hamburgers whose taxes supported the entire feudal system. Their task is to determine which laws have been violated and what measures should be taken to prevent similar incidents from happening again. But when they delved into the existing laws and regulations, they discovered some notable things. At that time, there was no explicit law prohibiting knights from competing while drunk. The laws of the Middle Ages were extremely complex, covering all aspects from the proper handling of surfing to the correct blessing procedures for holy water. But somehow, throughout the centuries of legal development, no one ever thought of explicitly prohibiting drunk knights from participating in races. This is to some extent because such behavior has traditionally been governed by a code of honor rather than written law. To act with dignity and skill, those who fail to meet these standards will be humiliated by their peers, excluded from future events, or deprived of privileges by their feudal superiors. But Heinrich's situation is different. He not only embarrassed himself, he hurt the clergy, which seemed to be a deliberate attack on the church itself. This requires a legal response, not merely opposition from society. The result was pioneering. It was the first law in Europe specifically prohibiting the damaged operation of medieval vehicles, in this case warhorse. This act was formerly known as the Medievaltrialexplained Martial Exercise Act. As a law resulting from a single event, its content is very comprehensive. It prohibits any knight, attendant or soldier from participating in contests, close combat or formal combat, under the influence of alcohol, malt liquor, spirits, or any other substance that may impair judgment or coordination ability. The law stipulates specific penalties for violations, ranging from being prohibited from participating in future competitions to losing knight privileges. It established a procedure for testing suspected violators, essentially a medieval on- sights or undertest, including the ability to balance, coordinate and recite prayers in Latin. Most strikingly, it has created a new category of legal liability. In European law, for the first time, intoxication was not regarded as a mitigating factor for criminal acts, but rather as an aggravating factor. If you hurt others while drunk, your punishment will be harsher rather than lighter, because you have chosen to put yourself and others in danger. This is a revolutionary idea. The legal system of the Middle Ages usually regarded drunkenness as evidence of a decline in ability, similar to madness or extreme youth. However, the Heinrich case established a principle that people are responsible for their drinking decisions and therefore for any subsequent consequences. Not everyone is satisfied with this new law. Knights throughout the empire protested that this violated their traditional rights and customs. They believe that moderate drinking is part of the knight culture, which helps to build comradeship that is crucial to military effectiveness, while being fully awake actually increases tensions and reduces social connections among participants, thus making the competition more dangerous. Some people even claim that this law is discriminatory because it only applies to the nobility. They pointed out that farmers can get themselves dead drunk at will without having to bear legal responsibility. Why should knights have higher standards? The church enthusiastically supports this law, considering it both a practical safety measure and a moral statement about the importance of self-control. The secular authorities were even more divided. Some believed this was a necessary reform, while others thought it was an unnecessary restriction on the privileges of the nobility. The implementation of proof is challenging. In medieval competitions, there were no alcohol testers, so officials had to rely on observations and testimonies to determine whether participants were harmed. This led to complex procedures, including balance tests, reciting prayers, and assessing the knight's ability to control his horse. The decree to abstain from alcohol at night spread throughout Europe at an astonishing speed. Within 10 years, the city-states of France, England, and Italy all passed similar laws. Each region has adjusted the basic principles in accordance with its own legal system and cultural norms, but the core concepts remain unchanged. Privilege comes with responsibility, and those who use weapons must do so calmly. This law also set an important precedent for the subsequent development of law. This is one of the earliest regulations in Europe to recognize that a person's mental state, at the time of an act, may affect their legal liability for that act. This principle eventually evolved into the modern concept of weakened criminal intent and capacity for conduct. More directly, it's changed the culture of medieval competitions. The early activities were characterized by alcohol-filled celebrations being replaced by more rigorous formal ceremonies. The knights still drank, but they did so after they had fulfilled their duties as marshals, not before. As for Rich von Schwarzburg himself, his story has an unexpectedly positive ending. This incident led to his public humiliation and significant legal penalties. He experienced the true conversion as described in medieval records. Heinrich became the patron of the monastery, where his brother Marcus was recovering from his injury. He donated to build a church specifically for the safety of the participants in the competition. Most strikingly, he has become one of the most effective advocates of the law created by his actions. In his later years, Rich traveled throughout the empire and told young knights about the dangers of combining alcohol with martial activities. His speech was described by chroniclers as both humorous and touching, clearly having a significant impact. Some sources believe that he has prevented many potential accidents through his educational efforts. He lived to be 62 years old and died peacefully in bed, which was a remarkable achievement for a medieval knight. At his funeral, his elder brother Marcus delivered a eulogy, praising Heinrich as a person who learned from his mistakes and dedicated his entire life to preventing others from making similar mistakes. The inscription on the tombstone has been preserved to this day, simply reading, "He walked with angels, but learned to walk with people." In medieval England, bread was more than just food. That's politics you can eat. Every loaf of bread is regulated by law. Every baker was under the watchful eyes of officials, and every crumb carried the weight of the royal authority. The rules for bread and malt liquor were one of the most comprehensive regulatory frameworks in medieval Europe, determining everything about bread production: size, weight, price, and quality. But among all these detailed regulations, not a single word is about shape. This oversight led to one of the strangest treason trials in British history. That year was 1327. During the tumultuous early reign of Edward III, Britain was still recovering from the chaos of the dethronement and murder of Edward II. This country has always been on the verge of war with Scotland, and every person in power is extremely sensitive to any criticism that might be regarded as a critique of the monarchy. In this atmosphere of paranoia and political tension, a baker in London is about to discover that artistic expression can be a dangerous thing. His name is William Baker. Yes, really. Baker William Baker. Because in the Middle Ages people were nothing if they did not name things literally. Everyone says that William is a highly skilled craftsman, famous for making bread that is both delicious and beautiful. In those days most bays were rough, dense, and purely functional. William was proud that the bread he created was both pleasing to the eye and visually appealing. Before baking the bread, he decorated it with complex patterns pressed onto the dough. He shaped the bread into delicate forms, braids, flowers, and even simple animal shapes for special occasions. His bakery was very popular among the emerging middle-class merchants and guild masters in London, who weren't able of spending a little more money on bread to declare their prosperity. Baking in the Middle Ages was subject to strict regulation, but these regulations focused on practical issues, ensuring that bakers would not deceive customers on their weight, that they used appropriate ingredients, and that they charged fair prices. The authorities are concerned about nutrition and the economy, not aesthetics. Therefore, when William decided to create his masterpiece, he had no reason to think that he had done anything wrong. It was a large round bread with exquisite patterns decorated around its edges. According to the standard, the weight of this loaf of bread is exactly correct. It is made of the best white flour. It is priced fairly in accordance with the established guidelines. The only unusual thing is its appearance. By medieval standards, the decoration that William pressed into the dough was a work of art. The raised patterns encircle the circumference of the bread, forming a complex geometric circle. From time to time, the pattern rises to the small mountain peaks, giving the entire decoration a unique appearance. For William, this is just delicious bread. For his customers, this is a model of craftsmanship that makes the bakers in London the envy of Europe. Thomas Daisy Gray, a royal clerk who happened to pass by William's shop. It looks just like a crown. This is not an ordinary crown, but the crown of England, a sacred symbol of royal power, the tangible manifestation of theocracy and the most powerful political symbol of the kingdom. Degra stood outside William's shop, staring at the decorated bread, his mind rapidly pondering its political implications. This is an ordinary baker, a person without rank or status, making bread that imitates the most sacred symbol of the monarchy. Is this deliberate mockery, a subtle incitement, an attempt to weaken the royal power by reducing it to something as ordinary as daily bread? In the paranoid political atmosphere of the 14th century, these issues were not academic ones. Criticism of the monarchy, even implicit criticism, is treason, and treason is a capital crime. Dig Gray reported his concerns to his superiors, who attached great importance to it and launched a formal investigation. Royal officials visited William's bakery, inspected the suspicious bread and asked the baker about his intentions. William's response might be the most honest and naive statement in the investigation into treason. "I just think it looks very beautiful." But honesty and innocence cannot resist the accusation of incitement. Officials confiscated several loaves of bread as evidence and began to file a case against the baker. They interviewed his clients to look for evidence that William encouraged the idea of treason. They examined his other bread designs, looking for patterns of anti-minus royal sentiment. What they found was that this person had nothing but artistic ambition and poor timing. William has never shown any interest in politics. He has never made any remarks criticizing the king. His only crime was making bread that accidentally looked like a royal coat of arms. But in medieval England, intention was often less important than appearance. The law on treason is deliberately ambiguous, encompassing not only active rebellion, but also any act that may damage the dignity of the royal family. What could be more disappointing than turning a symbol of royal authority into a baked product? The trial of William Baker was as serious as a major state prosecution. These accusations were officially read out, and bread was made in the form and style of a crown, thereby weakening the majesty and authority of our Supreme Lord King. The evidence was submitted to a jury composed of citizens of London. These crown-shaped bakers were on display, and a suspicious similarity to the royal coat of arms received full attention. Witnesses testified to the baker's skills and artistic cultivation. The prosecution believes that William's actions, whether intentional or unintentional, constitute an attack on the fundamental principles of the monarchy. By making bread in the shape of a crown, he reduced the sacred bread symbolizing royal power to the level of ordinary food. This is not only disrespectful but also dangerous, and may encourage others to think that the monarchy is ordinary rather than sacred. Williams defended himself by saying that he meant no harm and just wanted to make nice bread. But no one listened. The prosecutor reminded the jury that the law focuses on effect, not intention. If William's bread aroused people's disrespect towards the king, then no matter what his motives were, he was guilty. The jury deliberated for less than an hour before reaching a guilty verdict. William Baker was sentenced to death by hanging. This is the standard punishment for treason. But his case has attracted considerable public attention, and not everyone supports the prosecution. The guild leaders in London, many of whom were William's clients, asked the court for leniency. They pointed out that the baker is a skilled craftsman whose work has brought honor to the city. They believe that his artistic aspirations, no matter how misleading they are driven by the desire to better serve customers rather than to attack the royal family. The church representative Williams intervened. Several well-known clergy members argued that this case set a dangerous precedent. If artists and artisans could be executed for accidentally creating something similar to a royal emblem, where would they end up? Or painters be hanged for using too much gold in their religious works? Could stone carvers face death for creating architectural details that remind people of crowns? These disputes have clearly produced some effects. William's death sentence was commuted to public humiliation and a hefty fine. He was confined in a cell in front of the bakery, wearing a necklace made of his illegal bread, and a messenger read out the charges against him to any passer-by willing to listen. The fines were huge enough to bankrupt most artisans. But the Williams Association united to support him, helping him pay the fine and restart his business. But William Baker's case did not end because of his punishment. This incident exposed a major flaw in British law. If the symbols of the royal family are so sacred that accidentally copying them is an act of treason, then perhaps the law should clearly stipulate what constitutes illegal imitation of the royal family's monks. In the months following the Williams trial, Parliament passed what historians call Baker's Law, a comprehensive law defining serious symbolism. The law prohibits anyone from making, selling or displaying any items that are not in line with the symbols of the royal family, including crowns, scepters, royal seals and coat of arms. This law is very detailed and clearly stipulates that the ban applies to all kinds of handicrafts, including but not limited to metal, wood, stone, fabric and bread products. It even includes specific guidelines to determine whether similarity is inappropriate, essentially whether a rational person would mistake an object for a true royal symbol. Baker's Law has produced consequences that no one could have anticipated by clearly defining what constitutes serious symbolism. It actually clarifies what is legal. The craftsmen now clearly know where the boundary lies, and many of them have pushed it to the edge. Goldsmiths in London began to create exquisite jewelry, which legally incorporated the symbols of the royal family in terms of technology. The crown is clearly a crown, but the difference lies in that it can avoid being prosecuted. The scepter is clearly a scepter, but it has been fully modified to comply with the law. This led to a flourishing of creative interpretation, making London one of the centers of decorative arts in medieval Europe. Craftsmen who could have avoided any royal symbols are now competing to see how close they can get to the legal boundaries without crossing them. Perhaps more importantly, the case of William Baker changed the medieval perception of the relationship between art and politics. Before Baker's Law, artistic expression was usually regarded as politically neutral, a craft skill rather than a form of political speech. After the law was enacted, everyone understood that art could be political, regardless of whether the artist did it intentionally or not. This has endowed the artisans with a stronger sense of self and also made them more mature in artistic expression. Medieval artists learned to use symbols and fables in their works to encode political messages, which could be interpreted in various ways according to the viewer's perspective and political sympathy. This tradition of the dual meaning of art influenced European art in the following centuries. William Baker himself survived this ordeal and continued to have a successful career, although he was more cautious. He continued to make exquisite bread, but he was very careful to avoid any design that might be regarded as a symbol of the royal family. Ironically, his reputation as a baker who accidentally committed treason actually helped his business. Customers came from all over London to catch a glimpse of the man who was put to the test for making crown-shaped bread. Many of them bought bread as souvenirs, although William was very careful to ensure that there was nothing more politically sensitive in the bread than flowers or geometric patterns. In his later years, William became a spokesperson for the rights of artisans. He believed that artists should have clear guidelines telling them what is legal and what is not, rather than making them guess the political implications of their works. He lived to be 61 years old and passed away peacefully in bed, accompanied by his family and friends. At his funeral, the duelled president delivered a eulogy, praising him as a person who suffered for art and learned lessons from it. But perhaps the best way to commemorate William Baker is the continued popularity of decorative bread in London. The Baker's Law was originally intended to suppress artistic expressions that might challenge the authority of the royal family, but in reality, it encouraged the vigorous development of creative bread making, making London famous in Europe. Sometimes the best way to respect a symbol is to understand its hour. Sometimes a baker is needed to teach this lesson. At some point in the late 14th century, on the undulating hills of medieval Tuscany stood a monastery, which was supposed to be a refuge of sacred peace. The monastery of St. Angelo was the home of 37 Benedictine monks who have sworn poverty, chastity, and obedience. They pray during the day, meditate at night, and sleep soundly like the righteous at night. Or at least this is what they should do. What they did was actually to create one of the most disgraceful musical innovations in medieval history and, in the process, set legal precedents that would dominate religious behavior in the coming centuries. The story begins with a young monk Francesco. His intention to join this group was good, but the timing might have been the worst. Before taking the oath, Francesco had always been a popular musician, renowned throughout Tuscany for his proficiency in robbery and his mastery of secular songs, which were the entertainment of the nobility and merchants in the region's emerging cities. When he entered the monastery, Francisco faithfully gave up secular pursuits and focused on sacred music. The Benedictine tradition encompasses a rich heritage of religious chanting. Francisco devoted himself wholeheartedly to learning the ancient melodies that have reverberated in Christian monasteries for centuries. But the music of medieval monasteries, well, let's be kind and call it a challenge. Gregorian hymns form the backbone of religious music, which are slow, repetitive, and deliberately solemn. Their design purpose is to focus thoughts on God rather than entertain the senses. Beauty, when it emerges, should be ethereal and transcendent, rather than the kind of stomping, melodious music that Francesco remembered in his mundane days. During the first 2 years of his monastic career, Francisco was a model of religious discipline. He learned traditional hymns, participated in the daily office work, and kept his musical innovations to himself. But gradually, almost unconsciously, he began to make some small changes to the established melody. The notes here are a bit longer, and the rhythm there varies slightly. There's nothing dramatic. It won't draw the priest's attention in the formal ceremony either. Just some minor adjustments have been made to make the ancient hymns more interesting. Other monks began to notice. During the evening prayer, they found themselves listening to the music more carefully. The familiar melody seems fresher and more charming. They were looking forward to the musical part of the ceremony in a way they had never seen before. Inspired by his brother's concern, Francesco began to innovate boldly. He began to incorporate the musical techniques he had memorized from mundane life into it. Harmonies never heard in hymns, and patterns borrowed from popular songs, and melodic embellishments that make ancient lyrics seem almost modern. This transformation was gradual, but by the winter of 1384, the musical life of San Angelo had undergone a complete revolutionary change. The once serious hymns have turned into a form of entertainment. The crisis occurred during Christmas, when the monastery's music activities reached their annual peak. Francisco is now the unofficial conductor of the choir and has made special arrangements for the traditional Christmas carols. These versions not only incorporate his usual melodic innovations, but also include actual instrumental accompaniment, trophies, small drums, and even a small tambourine that one of the brothers somehow got. The Christmas vigil service that year was unlike any other in the 300-year history of the monastery. Unlike the solemn and contemplative atmosphere of previous celebrations, the church was filled with sounds that could only be described as joyous. The monks sang with great enthusiasm rather than raziness. Some of them swayed to the rhythm. At least one person was photographed patting their feet at what should have been a particularly solemn moment. But the real scandal occurred after the last service of the night minus the obedience ceremony. When the monks should retreat to their cells to meditate, Francesco initiated what he called extra prayer music. This was originally an evening concert, playing some popular songs. Francesco sanctified it by changing a few key words. A love song turned into a hymn to the Virgin in Mary. The drinking song turned into a celebration of the Eucharist. The tune of a physical tavern about an unfaithful lover turned into a contemplation of the new relationship between humanity and God. There is no denying that this music is very beautiful. It is undeniable that this is also inappropriate for a monastery specifically established to separate its residents from the pleasures and distractions of the secular world. Albert Benedetto had already noticed some unusual changes in the music of the monastery, but he initially welcomed them, considering them a sign of an increase in religious enthusiasm among his followers. The monks seemed to be more focused on their prayers and more willing to make offerings. What's wrong with that? But a Christmas vigil concert crossed a line that even the freest interpretation of the Benedictine tradition could not accommodate. When Benedetto discovered that his monks were actually holding secular concerts in the church during the designated silent meditation time, he was faced with a crisis that no monastery management manual had prepared for him. The problem is that Francisco's innovation is not explicitly prohibited by the current rules. The Benedictine rules written by Saint Benedict himself in the 6th century emphasized the importance of religious music, but did not provide specific guidance on what was acceptable and what was not. Later interpretations established some traditions, but none of these were formal laws. They are customary practices that have evolved over several centuries. Francesco's music is undoubtedly innovative. But is this really heresy? This is very interesting. But is this necessarily inconsistent with religious beliefs? It deviates from tradition. But is this naturally wrong? These questions might seem very academic, but in the monasticism of the Middle Ages, they had serious practical significance. Monasteries are largely autonomous, but they are also supervised by the church authorities. If the Bishop of Florence believed that San Angelo had deviated from acceptable practice, he could remove the abbot of the monastery, transfer the monks, or even close the monastery completely. The news of San Angelo's musical innovation inevitably spread to the outside world. Visitors to the monastery said that the sounds they heard were more like those from a tavern than from a sacred place. Local clergy complained that the monks had set a bad example for secular Christians, who might think that religious ceremonies should be entertainment rather than a challenge. The most serious issue was that a nearby monastery lodged a formal complaint with the Bishop of Florence. In contrast, the monastery's own musical tradition suddenly seemed dull. The complaint alleges that San Angelo abandoned its sacred traditions for secular entertainment and demands official intervention. Bishop Canna is a pragmatic person. He understands that religious innovation can be either a sacred inspiration or a dangerous deviation, depending on its ultimate effect. He appointed an investigation committee consisting of 3 senior clergy, 2 legal scholars and a religious music expert. The committee spent 3 weeks observing services in San Angelo, interviewing monks and analyzing Francesco's musical innovations. Their final report was a complex diplomatic masterpiece that successfully criticized the temple's practices while avoiding direct condemnation. The committee found that although Francesco's innovations were not heretical in terms of technology, they represented a dangerous departure from established traditions, which could lead to confusion among believers and reduce appropriate religious awe. Bishop Canna's response was prompt and comprehensive. He promulgated the Decreal 8, known as the Sacred Silence Decree, which was one of the most important religious legislations in Tuscany in the 14th century. This decree sets out specific guidelines for monastery music, requiring all religious songs to conform to ancient and recognized traditions. It prohibits the use of secular music forms in religious settings and the use of musical instruments for accompaniment in certain ceremonies. For Francesco and his fellow musical innovators, the most important thing was that the decree established a period of silence from compline to lauds, roughly from sunset to sunrise, during which no form of musical performance was allowed in the monastery. The decree is not only applicable to San Angelo. It was distributed to every monastery and convent in Sas, establishing a unified standard for religious music practice. Within 10 years, similar regulations were adopted in Italy and elsewhere. But the ban on sound is not just about music. It represents the broader efforts made by the church authorities to maintain control over religious innovation at a time when new Christian ideas were constantly emerging in Europe. This decree brought about consequences that no one had anticipated. By establishing clear boundaries for religious music, it actually encourages innovation within these boundaries. Composers across Europe began to experiment with various methods to make traditional hymns more beautiful and appealing, while remaining within the new legal requirements. This led to an unprecedented boom in religious music, which historians call the Holy Renaissance of the late Middle Ages. Composers have learned to create complex harmonies using only recognized melodic forms. They have developed new ways to set up traditional texts that are both legally acceptable and truly inspiring. The requirement for a distinct distinction between religious music and secular music also encouraged the development of a unique sacred musical language. Composers no longer adapted popular songs into religious ones, but began to create new musical forms that could only be used in religious contexts. Francesco himself became one of the leading figures of this movement. He was troubled by the investigation but did not lose heart. He was committed to creating music that was both innovative and traditionally acceptable. His later works were entirely composed within the constraints of the Decree of Silence and are now regarded as masterpieces of medieval sacred music. The Act of Silence set an important precedent, and its influence extended far beyond the field of music. This was one of the earliest systematic and detailed parts of church legislation to address the issue of religious innovation, establishing the principles that had influenced Catholic law for centuries. The decree acknowledges that traditions can evolve, but only under careful control. It established a procedure for evaluating religious innovations, requiring that reforms must be approved by the relevant authorities before implementation. Most importantly, it affirms the authority of the Church in regulating not only doctrine but also practice. It's not just about what people believe, but also how they express these beliefs. This principle will be at the core of the anti-Reformation efforts, aiming to standardize Catholic worship throughout Europe. After the decree was implemented, life in San Angelo underwent tremendous changes. The cheerful and innovative music culture created by Francisco has been replaced by strict adherence to traditional forms. The evening concert came to an end. The instrumental accompaniment vanished. The ancient hymns have regained their serious and contemplative nature. However, the spiritual life in the monastery has undergone a permanent change. Those monks who experienced Francesco's innovation will never forget what worship would be like when both their emotions and intelligence were involved. They found a way to bring the same sense of participation into traditional forms and discovered the depth of ancient hymns that they had never noticed before. Francesco continued to work in San Angelo for 23 years, becoming one of the most respected musicians in Tuscany, while strictly adhering to the decree of silence. He trained dozens of young monks to study the sacred art of music, not only imparting techniques but also their profound understanding of how music serves spiritual purposes. When he died in 1408, the music played at his funeral was completely traditional in form, but unprecedented in emotional power. The ancient hymns sung by the monastery for centuries seem to contain all the innovations and creativity that Francisco once brought to secular melodies. The story of Saint Angelo's musical revolution illustrates one of the core contradictions of medieval Christianity. The balance between tradition and innovation lies in preserving sacred customs and allowing them to evolve with the times. Francesco's innovation was not a rebellion against religious authority, nor was it aimed at secularizing sacred customs. They come from true piety and sincere belief that beautiful music can enhance rather than weaken the religious experience. But Christianity in the Middle Ages was based on the principle that some matters were too important to be left for personal judgment. For centuries, in order to achieve specific spiritual purposes, people have carefully developed sacred traditions. Even with the best intentions, changing them may have consequences that no one could have foreseen. The silence decree represents the Church's efforts to retain the necessary content while leaving room for appropriate development. This is not a complete ban on innovation, but rather ensures that change serves spiritual purposes, not merely aesthetic ones. Finally, Francesco's musical innovations did indeed transform sacred music, though not in the way he had originally intended. By compelling him to work within traditional constraints, the decree prompted him to discover possibilities in ancient forms that might never be explored. Sometimes the best way to encourage creativity is to set clear boundaries so that it can thrive. Sometimes we need a rebellious monk with stolen goods to teach us this truth. In the undulating countryside of medieval England, flocks of sheep grazed on the verdant hills, and ancient oak trees cast shadows over the babbling brook. Here lived a nobleman, whose relationship with his livestock might have been the closest ever. Lord Humphrey owned few possessions, but he had an excessive attachment to his carp pond, a relationship that eventually created some of the strangest legal precedents in the British legal community. Lord Humphrey's estate is located in the Yorkshire Valley and is a typical small noble estate in 15th-century England. He has a small manor, several hundred acres of farmland, and hilarious livestock, which provide food and income for his family. However, the most precious possession of his possessions was an artificial pond, which he had built at great expense and was home to top-quality carp imported from the Low Countries. These are not ordinary fish. In the Middle Ages, carp was a symbol of prosperity and refinement, and an expensive delicacy that only the rich could afford. Humphrey's carp pond is not only a practical investment but also a symbol of status, showing his wealth and elegant taste to visiting neighbors and presenting potential marital prospects to his daughters. But Humphrey's relationship with his fish goes far beyond ownership. According to contemporary records, he spoke to carp as if they were loyal servants, consulting them before making important decisions and even claiming that their swimming patterns could predict the weather and the outcome of legal disputes. If it weren't for what happened in the summer of 1447, this behavior might just be a harmless quirk. In the countryside of Yorkshire, this is a typical season. The crops were bountiful, the weather was pleasant, and Lord Humphrey's various businesses were thriving. The annual Midsummer Festival was particularly successful. Visitors from nearby estates came to admire Humphrey's garden, taste his malt wine and observe his famous carp. But in the days following the festival, Humphrey noticed that his fish behaved very strangely. Instead of swimming calmly in the pond as usual, they swam in an unstable way, sometimes so fast that they left obvious trails on the water surface. Occasionally, they would jump out of the water, and the splashing water could be heard from the entire manor. To most observers, this seems to be normal fish behavior, possibly caused by changes in water temperature or the presence of insects. But for Humphrey, who claimed to be able to understand the subtle communication of his underwater companions, this unstable swimming was clearly a painful signal. After several days of careful observation, Humphrey reached a conclusion that seemed obvious to himself, but was shocking to others. His fish is drunk. By the standards of the Middle Ages, Humphrey's theory was not entirely unreasonable. During the hot summer festival, people consume a large amount of beer and wine. It's very likely that some of the wine has already flowed into the pond. People in the Middle Ages knew that alcohol would affect animals. They observed the impact of fermented fruits on birds and knew that if horses ate spoiled grains, they would get drunk. But fish are different. In 15th-century Britain, no one had ever had the experience of drinking in water, mainly because no one would be so foolish as to pour good beer into a valuable park pond. Humphrey's first step was to summon the local Reeve Thomas Whitmore to formally investigate the matter. When Whitmore came, he hoped to deal with a simple livestock disease and perhaps needed the help of someone with veterinary knowledge. On the contrary, he found Lord Humphrey standing by his pond, holding a long stick, allegedly conducting a Wakefsmall's test on his carp. Humphrey explained that the testing process involved gently poking the fish and observing their reactions. He claimed that a conscious fish would swim in a straight line. Drunk fish will weave irregularly or not respond appropriately to stimuli. According to these standards, every fish in the pond was dead drunk. Whitmore dutifully recorded Humphrey's account and began to ask the festival participants about their activities near the pond. The story that emerged seemed to confirm Humphrey's most serious suspicion. Several young people from nearby estates, apparently encouraged by the festival beer, took part in what they called the toasting fish event, a drinking game. They first took a few sips of beer, then poured a small amount of beer into the pond, and at the same time made careful wishes for the health and prosperity of the fish. This practice seemed harmless at that time. In the Middle Ages, people oft unblessed their livestock with holy water and believed that sharing food and drinks with animals would bring good luck. These young people originally intended to show respect and celebration by toasting instead of causing trouble. But Humphrey has a different opinion. In his view, the villagers deliberately poisoned his precious fish, which might harm their health and, of course, disturb their peace. This is not a harmless celebration. This is an attack on his property. Considering his personal relationship with this fish, it is an attack on his family. Humphrey demanded that the people who tasted the fish be formally prosecuted, accusing them of deliberately intoxicating the aquatic creatures and disturbing the peace. Whitmore found himself confronted with a legal issue that no British court had ever considered. Can fish become victims of crime? If that's the case, what punishment should be taken for their so minus called drunkenness? Medieval English law was very comprehensive, covering everything from the proper handling of surfing to the correct procedures for trials through rigorous tests. However, there is no mention of intentionally poisoning fish anywhere in the code. This raises both practical and theoretical questions. If Humphrey's carp was indeed injured due to unauthorized drinking, what are the appropriate legal remedies? How can people determine whether a fish is truly poisoned rather than simply reacting to changes in the natural environment? For those who have no intention of harming others, no matter how foolish they are, what kind of punishment should they receive? Whitmore consulted the local sheriff, who then consulted the circuit judge, who eventually sought guidance from legal scholars at the University of Oxford. This case has sparked considerable debate among British common law experts, who have found themselves exploring issues such as the legal definitions of animal rights, property damage and intoxication. The resulting trial was unlike any trial in the history of British law. The defendants are three young men aged between 16 and 20-2, who are charged with deliberately intoxicating noble fish and infringing upon aquatic property. The evidence presented is both detailed and bizarre. Humphrey himself detailed lied demonstrated the normal behavioral patterns of his fish and the dramatic changes he observed after the festival. He presented what he claimed to be expert testimony about the psychology of carp and the impact of alcohol on fish metabolism. The defendant's lawyer argued that his client had no ill intentions and that their actions, in the worst-case scenario, constituted harmless pranks. He pointed out that no one was injured and fish did not seem to have suffered any lasting harm. The entire incident was based on speculation rather than confirmed facts. But the most memorable moment of the trial was when the judge insisted on personally inspecting the fish, which was said to be drunk. Throughout the courtroom, judges, juries, lawyers, defendants, and numerous spectators flocked to Humphrey's pond to take part in the famous Big Fish test of 1447. The judge observed the fish for nearly an hour, poked them with sticks, and consulted Humphrey about their behavioral patterns. His final conclusion was diplomatic and ambiguous. Although he couldn't be sure whether these fish were drunk or not, their extremely active behavior could be reasonably attributed to external influences. The jury found the defendant guilty of property damage, but dismissed the more serious charge of maliciously. They were fined a small amount and publicly apologized to Lord Humphrey and his fish. But the true significance of this case lies in that it has set a legal precedent. The court ruled that even if animals have not suffered permanent physical harm, they can still be victims of crimes, and regardless of the criminal's intentions, property owners have the right to protect their livestock from harassment. More importantly, this case led to the emergence of new legislations, specifically dealing with ornamental and luxury animals. The Aquatic Protection Act passed by the Parliament in 1409 prohibits the unauthorized introduction of any substances into waters containing precious fish. The later-known fish tasting case established several important legal principles that went far beyond the specific issue of the drunk carp. Firstly, it acknowledges that property rights include protecting property owners from acts that infringe upon their property enjoyment, even if such acts do not cause measurable economic losses. This principle was later applied to cases involving noise pollution, aesthetic damage and other forms of obstruction that are difficult to quantify. Second, its determination of intent is not always related to the determination of legal liability. Those who taste the fish have no ill intentions, but they still have to be responsible for the consequences of their actions. This helps clarify the boundaries of strict liability in British law. Thirdly, it acknowledges that animals can have legal status as victims, even if they cannot represent themselves in court. This is a very progressive concept that was not fully developed in British law until several centuries later. Apart from its legal significance, the fish tasting case also became a source of entertainment and moral education throughout England. The storyteller repeated the story over and over again until Lord Humphrey became a folk hero, renowned for his dedication to his aquatic companions. This story is used to teach the importance of respecting others' property, the dangers of alcoholism, and the unexpected consequences of seemingly harmless behavior. It appears in moral essays, children's stories, and even religious sermons as an example of how a minor sin can lead to big trouble. From the signs of taverns to the decorations of churches, artists have incorporated the image of drunken fish into everything. This theme has become a symbol of chaos, which might be caused by the abandonment of appropriate social boundaries and the importance of maintaining order in human and animal communities. Humphrey himself also became a celebrity, renowned throughout the UK for successfully prosecuting the person who poisoned his fish. He used his reputation to become an advocate for animal welfare, believing that owners have moral and legal obligations to protect their livestock from harm. In his later years, he developed what he called scientific fish farming, meticulously documenting the behavioral patterns and health indicators of his carp. His notes are kept in the British Library and are among the earliest systematic observations of fish behavior in British literature. When Humphrey died in 1461, nobles from all over Yorkshire attended his funeral, and many of them brought rare fish as gifts to keep his memorial pond. On his tomb, there is an inscription that reads, "Here lies a man who spoke to fish and caught them to speak with the law." Facts have proved that the legal framework established by the fish tasting case is very enduring. Similar laws for protecting ornamental animals have been adopted throughout Europe, and many of the principles established in this case remain part of British property law today. This case also set a precedent for what we now call environmental law. The idea that property owners can seek legal remedies for acts that disrupt their land use, even without direct physical damage, has become an important tool for protecting private property and public resources. Some theoretical foundations of modern animal welfare legislation can be traced back to the fish-tasting peasants' similar medieval precedents, which acknowledged that animals were not merely property. This case helped establish the principle that humans have a legal obligation to the creatures they care for, regardless of their economic value. Perhaps most importantly, this case demonstrates that the legal system of the Middle Ages was flexible enough to address entirely new types of problems. When confronted with situations that the law does not anticipate, British courts can formulate new principles that serve both justice and the actual social needs. Sometimes, the most important legal innovations come from the most unexpected places. Sometimes a nobleman needs to speak to his fish to remind us that the law exists to protect all members of the community, even those who cannot speak for themselves. In the summer of 1324, the French town of Sines received a magnificent new church bell. This large bell was cast in the finest bronze by a master craftsman from Flanders, decorated with complex religious images, and blessed by the bishop himself. It was originally intended to be the gem on the crown of the newly built Saint-Étienne Cathedral. This clock is extremely huge, with a diameter of nearly 8 feet and a weight of over 4 tons. It cost the small town a large sum of money, funded by special taxes and donations, and it will take 3 years to collect. The casting alone took 6 months. The bronze was heated in a specially built furnace and poured in a ceremony that attracted audiences from the entire region. The tolling of the bell does not merely represent a call to prayer. In medieval France, church bells were the voice of the community, marking the rhythm of daily life, announcing celebrations and tragedies, and calling on people to unite in times of crisis. The big bell is a source of civic pride and a symbol of prosperity and divine favor. The craftsmen who made this special kind of clock have surpassed themselves. Bronze is perfectly alloyed to achieve the best resonance effect. This shape is mathematically precise to produce the most beautiful tone. Decorative reliefs tell the story of redemption with intricate details, from preaching to resurrection. But the bell, which was destined to call on believers to pray in the coming centuries, rang only once before it became the defendant in one of the most unusual criminal trials in French history. This problem began with the inauguration ceremony of Big Ben. The people of Sangtown gathered in the cathedral square and heard their magnificent new bell for the first time. The bishop gave his final blessing. The bell ringer is standing beside the rope. The crowd fell silent, and hundreds of faces turned upwards towards the tower. The bell rang, its voice deep, loud and beautiful, enough to make an adult man cry joyfully, which was exactly what the people in the town were looking forward to. At that moment, years of sacrifice and expenditure seemed reasonable. This sound was like a pure wave of music, reverberating in this medieval town, on the stone buildings, touching the hearts of the entire community. Then the storm came. People in the Middle Ages were already accustomed to sudden changes in the weather, but the storm that occurred that afternoon was unlike any storm in people's memory. It simply emerged out of nowhere. At one moment the sky was still clear, but the next it was overcast with dark clouds, as if boiling with supernatural anger. First came the strong wind, which made people unable to stand and even damaged the decorative banners hung for the death knell ceremony. Market stalls collapsed one after another. Roof tiles were flying in the air like deadly projectiles. People scrambled to find any hiding place they could, pressing themselves against the walls of buildings and jumping into the door. Then hail came. It wasn't ordinary hail, but ice blocks the size of eggs that shattered the windows. The crowd scrambled to seek deeper cover. The sound was deafening. The continuous drum beats made it impossible to talk or think. But the real horror begins when the lightning starts. Lightning struck the cathedral one after another, illuminating the distinct and terrifying details of the Gothic spires. Several witnesses said that the thunder was so loud that it even drowned out the screams of the panicked crowd. The lightning strikes became more and more violent each time, as if the storm was gathering to some terrifying climax. People began to pray loudly, believing that they had witnessed God's wrath. Some people knelt in the square, disregarding the hail and the wind, begging for God's mercy. The last flash of lightning was different from all the previous ones. Rather than the previous brief, but brilliant flash, this bolt of lightning seemed to hover in the air for an impossible period of time, connecting the heaven and the earth with a pure white pillar of fire. When it hit the clocked hour, the sound it made was as if the world itself had split apart. The light was so bright that people covered their eyes, but they could still see it through their eyelids. The thunder that followed was not just heard. That was a physical force that seemed to be shaking the foundation of the earth. When the lights dimmed and the thunder ended, the crowd raised their heads and saw their magnificent new medieval from the tower, like a bronze meteor, trailing sparks and destruction behind it. What happened next was debated by the witnesses for decades. The bell was struck by lightning and fell from its pedestal, smashing through the floor of the bell chamber and embarking on a destructive journey through the cathedral, which seemed premeditated. First of all, it removed the wooden carved screen that separated the choir from the nave, a masterpiece of medieval craftsmanship that took 20 years to complete. The screen is carved by master craftsmen from the finest oak, decorated with scenes of Christ's life, and polished to a warm golden luster. A few seconds later, it turned into fragments and dust. But the bell did not stop there. It continued to rampage and smash the marble columns that had been supporting the cathedral's roof since the 12th century. The stone pillar is carved from a single piece of stone and decorated with complex capital letters, and is regarded as one of the best examples of French Romanesque sculpture. The bell shook it into a heap of rubble. The destruction inside the cathedral was systematic and thorough. But the path of the bell did not end on the wall of the building. It rushed in through the huge oak door at the entrance of the building. Those doors were elaborately designed to resist the army and have never been damaged by human power. After leaving the church, the bells continued to roll back and forth on the cobblestone streets of Sens, like some kind of bronze statue, leaving a trace of destruction with each turn. Witnesses said that the passage of the bells through the town was carefully considered and terrifying. It seems to search for the most valuable and vulnerable targets with incredible precision. First, it destroyed a silk store, smashed expensive fabrics imported from the East, and scattered precious dyes across the street. Then, it crushed a truckload of imported wine parked outside a tavern. The carriage belonged to a merchant who spent several months arranging the purchase of fine wine from Burgundy in the Lille Valley. In an instant, all his investments were destroyed. The wine mixed with soil and debris, forming a deep red stream that flowed through the drainage ditch. Subsequently, Big Ben destroyed a goldsmith's workshop, scattering precious metals and semi-finished jewelry all over the square. The master craftsman who was watching from the nearby building couldn't help shedding tears when he saw the exquisite works of several months destroyed in just a few seconds. Finally, after destroying a fruit vendor's stall and embedding itself into the wall of the town's most expensive hotel, that big clock was able to rest. The impact was so violent that the foundation of the inn cracked and part of the second floor collapsed. When the big clock finally stopped moving, the damage it caused in 10 minutes was more than that caused by most natural disasters in just a few hours. The property loss is huge. Thousands of goods and buildings were destroyed. But more disturbing than the material loss was that the people in the town felt they had witnessed something that could not be explained by nature. In medieval France, nothing happened by chance. From the smallest personal misfortunes to the greatest natural disasters, everything is understood as occurring within God's sacred plan. When lightning strikes a church, it is not a random meteorological event. This is a message from heaven. But what is the information within it? Did God reject the bell? Is he not satisfied with Sens town? Did the cathedral offend the sacred emotions? These issues are not merely theological ones. They have a practical impact on a society that relies on God's grace, from a bountiful harvest to protection from enemies. Bishop Sens was confronted with the most unusual crisis in his church career. He convened a committee composed of theologians to investigate the impact of the bell's behavior on the spirit. Their task is to determine whether the destructive frenzy of the clock is the act of God, the act of the devil, or, most disturbingly, the act of free will of an inanimate object that has somehow acquired the ability to make moral choices. The investigation lasted for several weeks. The witness was questioned repeatedly. Their accounts are carefully recorded and compared. People examined the structure of the clock to see if there were any signs of demonic influence. Was the bronze contaminated during the casting process? Did the craftsman unknowingly add the cursed material? Was it the enemies of the church who disrupted the blessing ceremony? People inspected the foundation of the cathedral, looking for evidence of ancient curses or pagan contamination. Scholars have extensively studied historical records, seeking any precedents that might explain how a blessed person could become violent. Finally, the committee reached a conclusion that no one was satisfied with. But considering the evidence, this conclusion seemed inevitable. The bell was deliberately malicious when attacking the town. It is impossible to determine whether this malice is a divine revelation, the influence of the devil, or some inherent reason of the clock itself. But if Bell did it intentionally, then it may have to bear legal responsibility for its actions. The trial of the Sens bell was carried out in all the solemn atmosphere that the French legal tradition could evoke. This bell, still embedded in the damaged church wall, has been officially charged with maliciously damaging property, attacking sacred buildings, and disturbing the peace of Christian souls. As the beak bell was unable to defend himself, the court appointed a defense lawyer, the young one named Philippe A. Dionne Moroni, who later became one of the most respected legal scholars in France. Although he has always claimed that defending an inanimate object is the most challenging case of his career, Batermorin's defensive strategy must have been creative. He believes that Big Ben is the victim rather than the perpetrator. It is an innocent object that was struck by lightning and was not at fault for being thrown out of the cathedral. He claimed that the subsequent destruction was the result of natural forces rather than an intentional act. The prosecution, led by the town's senior judge, refuted what they called malicious evidence. They pointed out that the big clock seemed to have deliberately crossed the town. Its target was clearly valuable property, and its final act was to bury itself in a building rather than simply roll to a harmless place. Expert witnesses witnessed the normal behavior of falling objects, the typical patterns of storm damage, and the theological implications of the destruction caused by blessed objects. This case has drawn attention from all over France, and legal scholars have flocked to Sens to observe the trial. The trial lasted for 3 days and attracted audiences from all over France. Legal scholars came to observe the litigation process. Theologians attended the meeting to ensure that appropriate attention was given to the spiritual meaning. Even foreign political leaders sent observers, curious about how the French judiciary would handle such an unprecedented case. The jury's verdict is a masterpiece of compromise in the Middle Ages. They found that Jean had committed the crime of property damage, but with no ill will. Big Ben did cause huge losses, but this was due to circumstances beyond its control rather than intentional errors. This sentence is equally creative. This clock will be expelled from Sens town for a period of 7 years. During this time, it cannot be used for any sacred purposes. After this period of punishment, it can be recast into a new bell and will have no blemish of any criminal act. But this case established something more important than punishing a rogue. It created a legal framework for dealing with what medieval jurists called inanimate malicious acts, in which objects seem to cause harm through their own agents rather than through human actions. In the months following the trial of Bell, similar laws were passed in France and elsewhere. The Inanimate Liability Act established procedures for dealing with objects that cause harm due to their own obvious effects. This law acknowledges that although objects cannot form intentions as humans do, they can still be held responsible for damage if their actions exceed the reasonable expectations of natural forces. A violent reek rushed a house in a storm. It was an accident. Even without human intervention, the destruction of property by the rolling chimes in the town is a criminal act. This regulation establishes the criteria for determining when the behavior of an object constitutes a criminal activity. The key factors are the obvious intent of the act, the extent of the damage caused, and the extent to which the act exceeds the normal expectations of such items. Objects found to have committed criminal acts can be punished through exile, destruction, or purification. This process involves blessing the object and, in many cases, making physical changes to it to eliminate any tendency for future misconduct. The impact of inanimate liability regulations goes far beyond the practical issues of dealing with destructive objects. It represents a complex attempt to address fundamental questions about the nature of agency, responsibility, and causality. By acknowledging that the object could be held accountable for its actions, medieval French law recognized that the boundary between human and non-human agents was far more complex than traditional legal theory believed. This was a remarkable philosophical development that academic philosophers did not fully explore in the following centuries. This law also established the principle that responsibility is related to consequences rather than intentions. It doesn't matter whether the bell of sin means causing damage or not. What matters is that it has caused damage through actions that exceed normal expectations. This principle has influenced the development of strict liability law, which holds that individuals or entities can be held responsible for damage regardless of their intentions or the extent of their care. The concept that objects may behave improperly helped lay the foundation for the legal framework that later managed everything from industrial accidents to product liability. The story of the Sens Bell has a surprisingly positive ending. After spending 7 years in exile in a warehouse outside the city, this clock was indeed recast according to the court's judgment. Master craftsmen from all over France attended the recasting ceremony, as did representatives from the church, the legal community, and the royal family itself. In 1331, a new bell named Redemptio Redemption was traced in Saint-Étienne Cathedral. For more than 2 centuries it has been ringing safely and has become one of the most popular and reliable clocks in France. It is said that its voice is even more beautiful than that of its predecessor, as if the experience of judgment and punishment has purified its voice to some extent. Local legends say that the voice of redemption can calm storms, heal the sick, and bring peace to troubled souls. Whether these claims are true or merely the product of civic pride, this bell has indeed brought peace to the town of Sens. For 7 years this town had been worried that it would be displeased by the gods. The trial of Sens Bell established legal precedents that have influenced European jurisprudence for centuries. The concept that inanimate objects can be responsible for their own actions provides a framework for handling technological development, which medieval legislators could never have imagined. When watermills began to cause floods, when mechanical clocks started to disrupt peace, and when cannons began to explode unexpectedly, the European Court of Justice had legal precedents to solve these problems. The principle established by the Bell case that responsibility is related to outcome rather than intention laid the foundation for regulating technological innovation throughout the late Middle Ages and the early modern period. This case also affected the development of international law. The view that both objects and people can be subject to legal jurisdiction helps establish principles for handling cross-minus disputes involving ships, trade goods, and other mobile properties. Perhaps most importantly, the Belson case represents an early example of a legal system's efforts to address the essential issues of agency and liability, which remain relevant to this day. Medieval jurists, in the face of situations that did not conform to the existing legal categories, created a new framework acknowledging the complexity of causality in human affairs. Their solution is to hold objects accountable for their actions while recognizing that this responsibility is different from human moral behavior, which is complex both in practice and philosophy. It offers a solution to practical problems while acknowledging that the universe is more complex and mysterious than what human law can fully understand. This case also demonstrates the flexibility of the medieval legal system. When confronted with a completely unprecedented situation, French courts are able to formulate new principles to meet both practical and spiritual needs. Finally, the bell of sin told medieval Europe that justice could be both practical and transcendent. The existence of the law is to meet human needs, but also to acknowledge the mysteries of God. Sometimes the most profound legal innovations come from the most unexpected sources. Sometimes an out-minus of minus control alarm bell is needed to remind us that the law must be flexible enough to deal with even the most unlikely situations. As we approach the end of our journey through the peculiar legal landscape of medieval Europe, it is worth reflecting on what these strange cases tell us about the people who created them and the world they were trying to understand. Thick judgment, night goose, drunken fish, crowd minus shaped bread, musical monk, and out minus of minus control chimes. All these cases appear in a society that is attempting to create order in a chaotic and unpredictable world. People in the Middle Ages lived in a world where supernatural phenomena were real and direct. They expected divine intervention, and the boundary between nature and miracles was constantly changing. Their legal system reflects this worldview and has created a framework that can solve everything from practical problems to spiritual crises. In the eyes of modern observers, the absurdity of medieval law often reflects different understandings of causality, liability and agency, individual rights and community welfare. People in the Middle Ages were no smarter than us. They have different assumptions about how the world works. When they brought a pig to court for murder, they weren't acting foolishly. They employed a complex theological and legal framework to attribute moral responsibility to all of God's creations. When they forbade knights from bestowing titles upon geese, they were not stingy. They are protecting the sacred institutions from being looked down upon. When they regulate the nighttime activities of musical monks or set dress codes for naked carpenters, they are balancing personal expression with community needs in a way that requires considerable legal creativity. Many of the legal principles established by these bizarre medieval cases still apply today. The law must balance competing interests. Individual rights must be weighed against social welfare. The legal system must be flexible enough to address entirely new types of problems. These concepts were developed through the cases of the drunk knight and the egg-laying rooster and continue to influence modern jurisprudence. The Middle Ages also set important precedents for administrative law, environmental regulations, work safety, professional ethics, and other aspects. The origin of many modern legal frameworks can be traced back to innovations in the Middle Ages, which originated from the need to solve practical problems in complex societies. Perhaps most importantly, these medieval cases remind us that human nature has remained astonishingly unchanged over the centuries. The same impulse that drove medieval bakers to create artistic bread also drives modern artists to break through the boundaries of creativity. The same social concerns that led to the noise regulations in the Middle Ages have inspired modern legislation on quality of life. The tension between personal expression and social responsibility that was unique to medieval monasteries continues to influence the debate on religious freedom in modern society. The need to strike a balance between practical requirements and social etiquette once challenged medieval legislators, and this need continues to influence contemporary policy making. The legal innovation we are discussing tonight emerged during a specific period in European history when traditional medieval structures began to give way to early modern institutions. Many of these laws were formulated during a period of social transformation, when old certainties were disintegrating and new approaches were needed. By the late Middle Ages, the worldview that gave rise to pig trials and rooster executions began to change. The rise of scientific thought, the growth of secular authority, and the development of more complex legal systems have gradually reduced the influence of supernatural explanations on unusual events. However, the legal framework created during the Middle Ages did not disappear. They kept evolving, adapting to new environments and continuing to influence European law in the following centuries. What can we learn from these strange stories about justice in the Middle Ages? Perhaps the most important lesson is that legal systems are human creations, shaped by the beliefs, fears and desires of those who created them. Those laws that seem the strangest to us today are actually logical responses made by intelligent people to practical problems based on their understanding of how the world operates. This should keep us humble about our legal innovations. The laws we make today based on our current understanding of human natures, social needs may strange to future observers, as the pig trials of the Middle Ages seem to us. But it should also inspire people's confidence in human adaptability. Facts have proved that the legal system of the Middle Ages had extraordinary creativity in addressing entirely new types of problems. They developed innovative solutions, balanced competing interests, and created a feasible framework for governing a complex society. In our modern world, we have largely abandoned the medieval belief that supernatural forces directly interfere in daily life. For most phenomena that were once regarded as magic or demons, we have scientific explanations. We know that roosters don't lay eggs, fish don't get drunk, and bells don't have ill intentions. But perhaps we have lost something in the process of gaining this understanding. People in the Middle Ages lived in a world full of miracles and possibilities. Both miracles and disasters were possible, and sacred things could intrude into daily life at any time. Their legal system, though seemingly absurd, reflects a profound belief that everything is important, every living being has meaning, and every action has an impact, affecting both the natural and supernatural realms. When we conclude our journey through the strange legal landscape of medieval Europe, it is worth remembering that these are not merely treasures of history. They are real events that influence the lives of real people. Behind every strange law lies a group that attempts to solve practical problems, maintain social order, and understand a complex and often perplexing world. A pig convicted of murder, a goose that became a knight, a drunk fish, and a baker who nearly lost his life while making artistic bread. All these cases involve real animals and real people whose lives have been changed by legal innovations resulting from the environment they are in. Medieval law may seem strange to us, but it originated from the same human needs that drive the development of law today. The need for justice, the yearning for order, and the hope that society can be organized in a way that protects individual rights and community welfare. Finally, perhaps the most striking aspect of medieval law is not how different it is from the modern legal system, but how similar the underlying concerns of humanity are. Back then, just as people do now, all hoped to live in a community where they could pursue their dreams, express their creativity, and be free from uncontrollable forces. The laws they have formulated, no matter how strange they may seem to us, represent their greatest efforts to build such a community and have achieved success in many aspects. So, the next time you come across a law that looks particularly strange or bureaucratic, please remember the pig in port, the goose in armor, the priest who defeated the knight, and the rooster that laid an impossible egg. Please remember that every law has a story, and every regulation stems from the genuine needs of humanity. The grand project of human justice is constantly evolving, and a strange event occurs at a time. Thank you for joining me on this wonderful journey of medieval law. See you next time. Have a good sleep and dream of a world where even pigs can live.